it's time for IP in the news. And so who are we IPing in the newsing today?
Well, we are going to talk about the value of patents because Columbia University was awarded over $185 million for patent infringement by
Norton LifeLock Incorporated. So we can talk about this because it's in the public domain. But what happened with the lawsuit?
Well, Norton LifeLock, who protects other people from cybersecurity threats, took some cybersecurity protection software from Columbia and used it in their product.
Right. So really not such a good look for Norton LifeLock, I guess. What were they thinking, right? And it's not like they just developed it independently. They worked with Columbia University to develop the technology. And so, of course, of course, Columbia got mad and they filed a lawsuit about it. And one of the interesting things was that LifeLock went behind Columbia University's back and filed a patent also covering their technology. And Columbia never knew about it. And so part of the lawsuit was to get the inventorship on that hidden patent.
They filed a patent application. Did it issue as a patent?
Yes, it would have had to because it was in a patent lawsuit.
So the patent would be invalid if it didn't have proper inventorship.
Well, that's always a potential. The case law is split on that, but I would say for our listeners, one of the IP takeaways from our roundtable today is making sure that you get the inventorship right on your intellectual property, because knowingly leaving somebody off can be the basis for making your patent bad and making it unenforceable.
So let's do Richard's roundtable.
All right. Sounds like fun. Welcome to the show, John. So great to see you. You're our first target for Richard's roundtable. Tell us what you think.
Richard, no, fascinating. It reminds me of a political story where they're doing what they say not to do. But I think it's very relatable to general business too. And, I always say the partnerships are great until they're not. So here they are, they've collaborated on a development, but things weren't clearly spelled out, whether it be in a business, in the operating agreement, or in your world, in the IP world. Having scenarios play out and thinking ahead of time saves a lot of money and legal cost and issues down the road.
Absolutely. And, your specialty is franchising, as we mentioned earlier. And so part of the franchise model is having things, spelled out so that there is clarity around these issues. And it'd be interesting to get your take on intellectual property franchises if a franchisee invents something a little bit later. But no, that sounds like a really incredible connection. Banzi, what are your thoughts?
It's surprising that a company like Norton, who knows everything about infringement and still willfully went on doing infringing on somebody else's work. I mean, we have situations here in our clothing industry whereby we unknowingly do infringe on each other. But of course, the laws, I guess, in our industry, or at least in our products, are not so stringent. So the intellectual property rulings may not apply as much in our industry, but clearly in Norton's case, I mean, it's an embarrassment what they did.
$185 million embarrassment.
Yeah, and I'm not knocking Norton. I don't know anything about them as a company. It could be that this was some sort of accident. Infringement doesn't have to be intentional, or maybe they were a little bit too aggressive. Sometimes that happened, but they obviously, I think, hopefully learned a lesson through this experience. In the clothing industry, you're right. I mean, clothing is harder to protect through intellectual property, at least the design and the look of the fashions are difficult. And it's really well known in the, that the designers, they do their designing, and then everybody looks at the designers and they make kind of adjustments. They change the materials, they
That's
change
right.
the cut a little bit, and then they sell it as a product. And that's how the whole industry, works.
Yeah, in a way, they say there is no original. Everything is a take from somewhere else and modified.
Right. And so in those cases, you can certainly trademark your brand, which we would always recommend. But
Yes.
unless there's something kind of special about the clothing, it is kind of difficult to protect. And we think about, for example, about retro fashions where they start borrowing from years ago. So everything is old is new again, I suppose.
Absolutely. So who's next?
Yeah.
Who is next? What are your thoughts on all of this stuff?
I mean, I'm not very, huge in Japan. I don't know a whole lot about it, but I mean, while you were talking, I looked up Norton LifeLog's market cap, and it looks like they have to pay 180 million, but being worth 14 billion, that sounds like a speeding ticket to me, because at the end of the day, it must be worth their time somehow, because they're $14 billion, that's a small price to pay. I have a car right now and I'm driving, I get a ticket, I pay the ticket, I keep moving, and I get where I'm trying to go to. So if I have a meeting to get to, and the meeting, I'm gonna make $1 million in that meeting, I have to pay $200 ticket, I'll pay the ticket, and then I'll get to the meeting, on time. So, but I'm currently going through the patent process right now. So I'm kind of, getting a lot more versed in patenting, but it's really hard, like in textiles, to patent anything.
Yeah.
When I was on Shark Tank, they were like, why are you patenting patents? And I'm like, patents in textile, good luck. I mean, it's possible, but it's very hard. So, because you just have to change a few things here, like you said, and then you're not infringing anymore.
Right. Yeah. I would agree with that. I mean, textiles has been a place where there's been a lot of investment for a long time, and in technologies. And so there's a lot of it's hard to do something, from a technical perspective that's really new in textiles. So the patents tend to be narrower in scope. But from a marketing standpoint, there's obviously plenty of potential, and I see that you're capitalizing on that. Kenya, what are your thoughts?
Well, to Wen's point, that's a really expensive speeding ticket. So whether I had the money or not to pay it, I don't know that I would feel so good about paying it. My question is more for you, Richard. What would you advise your clients, right, in this situation, like to do ahead of time to kind of get protected and so on and so forth?
Well, thank you for asking. And first of all is something that John brought up, which is the contract, and making sure that it's really, it's really clear, and that you have, the legal tools can only take you so far. They're important, but at the end of the day, it's the business relationship that matters the most, and the legal stuff is only there as a backup. So you definitely want to pay attention to it, but you also want to have the right kind of relationship with your partner. And if you're at the point where you're suing each other, that means the business relationship went south, right? And basically because they couldn't work it out. And so that's one of the things. Choose your partners carefully, but then also have a good contract and good communication, so everybody knows what's going on, because somebody probably found out about this by surprise, and they got upset, and so that prompted a lawsuit. So all of the things that you would do to conduct business in a positive way, you need to always do that. And that will help keep you out of lawsuits. So, and then if somebody is infringing, you do try to work it out. They should be getting some sort of royalty for their work, some sort of credit for it. And obviously they weren't for some reason. And that's what provoked this.